Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-5200. William Edward Powell, appellant, versus Janet L. Yellen in her official capacity as Secretary of the United States Department of Treasury, et al. Mr. Shelley, amicus curiae for the appellants. Mr. Christensen for the appellees.
Mr. Shelley, good morning.
Morning, may it please the court. I'm Anthony Shelley, the court-appointed amicus in support of appellant William Powell. I've reserved 2 minutes for rebuttal. This appeal requires the court to address 3 of its prior precedents involving the Internal Revenue Code provision authorizing taxpayers to obtain their own tax returns, their own taxpayer information. The 3 cases are Church of Scientology, Lake, Maxwell. There are 3 ways to deal with these precedents, 2 of which lead to Mr. Powell winning this appeal, and a third, which is favored by the government, but that is foreclosed by the court's obligation to seek to harmonize precedents rather than discard them. So first option 1, that would be to hold the Church of Scientology finds FOIA procedures, such as the time and manner of making a disclosure request, that they apply to the disclosure of information at the administrative level, but that under Lake, a judicial action to compel disclosure is governed by 6103 of Internal Revenue Code. That's the reading I put forth in my amicus, my opening amicus brief, and it follows from the exact wording of Maxwell, which indeed tried to harmonize Church of Scientology and Lake, or took a first pass at that. It also follows from Judge Henderson's concurrence in Essential Information versus USCA, where Judge Henderson noted that specific statutes authorizing disclosure override FOIA, whereas the non-disclosure parts of a statute do not override. And here, Mr. Powell sues to enforce the disclosure aspects, 6103. Should the court adopt this first option, to read the cases that way, Mr. Powell wins this appeal. The district court's decision holding that he had to use.
Is there any precedent that supports this kind of bifurcated or different approach, FOIA at one level and APA at a different level? Like, I've never seen this before.
Well, there isn't, but you have to try to make sense of 3 cases here, but also under 6103.
But why doesn't what Maxwell said make sense of the 3 cases? Maxwell just says that Lake said just dealt with the Privacy Act versus FOIA and held that the Privacy Act is not operative. That FOIA is, or 6103 is. I'm sorry, 6103 instead of so I think that Lake can be read, as we said in Maxwell, to just say that Lake was looking at whether 6103 is applicable versus the Privacy Act, and it held that 6103 is the way to go. But then when you harmonize that with Church of Scientology, 6103 is an exemption under Exemption 3 of FOIA. It seems that Maxwell has done the work here.
Well, Judge Pan, you're I think looking at one paragraph in Maxwell where Judge Santel did note that Lake was a Privacy Act case, but the next paragraph then is the part that really tries to harmonize them by saying they're easily harmonized, and Lake does not speak to whether FOIA requirements should apply to the processing of appellant section 6103 requests. So Church of Scientology clearly controls this case in requiring FOIA procedures. The district court was thus correct in holding that FOIA still applies to section 6103 claims. And in fact, in Maxwell,
But so if FOIA applies to 6103 claims, why can't that be all the way through?
Well, because a 6103 claim is not a FOIA claim. It's a 6103 claim. And in fact, in Maxwell, the plaintiff invoked only 6103 in the APA, and it was, and the court affirmed part of the disclosure of information, I think. And so the court wasn't saying you must raise a FOIA cause of action. In fact, it was saying the opposite, that in affirming the aspects of the district court where the district court said, when you sue under 6103, the IRS at least has to make sure your request.
But the district court in Maxwell construed the 6103 request as a FOIA request. So when we affirmed that, we affirmed treating it as a FOIA request. And indeed, Maxwell goes through kind of the FOIA analysis when it gets to the substance of what should or shouldn't be disclosed, right?
Well, two other aspects of that then that I want to address and kind of interplay the two questions, Judge Wilkins and Judge Pan. And one is that the bifurcation theory does make sense because under 6103 P, it is the IRS that's supposed to determine the administrative procedures that apply. And the IRS has determined that its FOIA procedures will apply in these circumstances. So 6103 can be read, at least at the administrative level, to leave it to the IRS to pick how is a person to seek to collect their own information. How do you make the request? And the IRS hasn't issued separate 6103 regulations.
Wait, but the case law doesn't say we left it to the IRS and the IRS chose FOIA. As a matter of statutory construction, we said that in our prior cases that this is part of FOIA Exemption 3, that 6103 is part of FOIA Exemption 3.
Well, this doesn't involve, I think, the that FOIA exemption. What we're having here, under Church of Scientology, the exemption that there's an additional exemption contained in 6103 that was at issue. That's not at issue here. The other thing I want to mention is that Mr. Powell's requests are really Privacy Act-like requests. They're not FOIA requests. They look like exactly the ones that were made in Lake. And the court there said, if you're seeking your own information, that's a 6103 claim, which then is picked up, at least in the language, not the district court's way of looking at least in the language of Maxwell at the Court of Appeals level. And so if you look at he didn't cite any of these. He didn't cite the Privacy Act, he didn't cite FOIA, and he didn't cite the APA. You have to look at the substance of his claim, and it's really for his own information that he's seeking, which is actually a Privacy Act sort of cause of action, not a FOIA cause of action. This isn't the request for public information in general to determine if the government is acting well. It's instead a specific request under a specific statute for his own information that looks like a Privacy Act kind of claim. So you have to turn most to Lake then, where Lake says, we displace FOIA, we displace the Privacy Act, and so therefore if we accept that
I don't think that Lake says anything about displacing FOIA that we can really kind of read that broadly.
It doesn't
when
mention
I looked at the briefing in Lake, the appellants in Lake explicitly said, we don't want to use FOIA and we're not making FOIA requests. And like the reply brief on appeal in Lake, they said, FOIA isn't, the right statute to provide this type of information to the American people, et cetera, et cetera. Like the appellants in Lake, for whatever reason, didn't want to have FOIA be considered at all with respect to their requests for their tax information. So naturally, our court, in disposing of their claim, wasn't deciding anything about FOIA because they weren't relying on FOIA. I mean, the way that I read these cases in the statutes is that, look, we said in Scientology, the FOIA disclosure statute has these 9 different exemptions. One of them is if something can't be disclosed by statute, well, 6103 marries completely with exemption 3. And what we said in Lake was the Privacy Act, to the extent that it has substantive non-disclosure kind of specifications, those are overridden or superseded for tax purposes by the standards, the substantive standards in 6103. And so if we're not going to follow those substantive standards, then we're not going to follow the cause of action under Privacy Act. And so I think based on that and based on our decision in Gardner, you bring an APA claim to, if you are challenging wrongful disclosure of your tax information in violation of 6103. I think there you have an APA claim because there's no Privacy Act claim. But if you want disclosure of your own tax information, Church of Scientology and Maxwell says it's FOIA.
Well, what I would point out, though, is that in Lake, there is a discussion of FOIA, and it's a discussion of FOIA to support the Privacy Act. The Privacy Act aspect of the Privacy Act being displaced, and says we displace the Privacy Act because, in fact, we would displace FOIA here as well. And that's where Judge Henderson's concurrence was cited, for instance, for the prospect that if you're seeking the disclosure of your information, then you must rely on the specific statute. If you're seeking to if you're seeking to avoid non-disclosure. So, for instance, in Church of Scientology, that was really about an exemption from disclosure. And that was then the extra exemption in 6103 was engrafted onto FOIA. But here, this really isn't about that exemption. This is about seeking disclosure of your own information rather than prohibiting disclosure.
Well, the Church of Scientology, the California church, was seeking their own tax records, but they were also seeking records related to the national church and L. Ron Hubbard, the founder of the church. And so we treated all of that as FOIA and said, well, under Exemption 3 and 6103, you can have your own records from your California church, but you can't have these other records.
And Church of Scientology, I mean, the cases don't mesh perfectly. That's why we're here with a fourth case, really. They have to be harmonized. And so Church of Scientology does have two parts to it: seeking your own information and seeking information about other entities. And as a result, it was largely the latter. Therefore, that's very consistent with our theory that if you're seeking information that's not yours, that's not the part that 6103 specifically concerns disclosure about it. That's the part that concerns non-disclosure. And
so it seems to me, counsel, that your argument relies on the assertion that Lake, it's really relying on Lake and saying that Lake says there's a 6103 cause of action, and to the exclusion of FOIA. But Lake doesn't talk about FOIA, like it just doesn't mention it. So isn't the more logical way to read this as Lake just compares Privacy Act cause of action to 6103 cause of action, doesn't address FOIA, and then FOIA comes in Maxwell and Church of Scientology and says that that's what we're doing here?
Well, with due respect, I think Lake does discuss FOIA. After the court talked about the Privacy Act being displaced, it says a comparison of the precise treatment of return information under 6103 and the imprecise regulation of agency agency records in the Privacy Act reveals many other differences. In analogous circumstances, we have held that the Freedom of Information Act does not govern the disclosure of information when, in another statute, Congress has
But
dealt
it didn't apply FOIA, it just mentioned FOIA as an example, right?
Well, correct. It used FOIA, Judge Henderson's concurrence, all to support what it did. But I will agree with you that a Privacy Act claim was made there, not a FOIA claim. But my point would be, well, Mr. Powell has a Privacy Act. The facts of his case and what he stated in his Second Amendment complaint are closest to a Privacy Act claim. The court has to determine the proper characterization of the complaint. It's not a FOIA claim. It's not seeking general information about the government. He's seeking information about himself, his own tax returns, the tax returns of companies in which he is the heir, essentially, and the tax information about estates that he administers. And so when you're seeking information about yourself, that's more so a Privacy Act claim as opposed to a FOIA.
So if we think that he can't bring a Privacy Act claim, where does that
Goes
lead
to Section 6103 with an APA claim, as Lake says. That was what should have happened in that case. And because the plaintiff didn't want to do that because they feared that an exception from, an exception not relevant here from 6103 would be invoked against them if they brought the 6103 action. So they wanted to use the Privacy Act instead, and the court said, no, you must do 6103, you get the good parts and the warts with it, and you go through the APA. You can't use a Privacy Act claim and avoid the specific things Congress said in 6103. Gone over my time.
All right, if there are no more, we'll give you a couple of minutes in reply. Thank you.
Thank you, Your Honor.
Mr. Christensen.
Good morning. May it please the court, Jacob Christensen, and I represent the appellees in this case, the Commissioner of Internal Revenue, Secretary of the Treasury Department, and their respective agencies. This court has already twice decided the very issue that is being raised in this case, which is that Section 6103 of the Internal Revenue Code displaced or superseded the disclosure provisions of the Freedom of Information Act. Church of Scientology, and then again in Maxwell, this court rejected that argument, holding that Section 6103 instead gave rise to an exemption under FOIA, but that FOIA's procedures continued to apply to requests for tax records from the Internal Revenue Service. This court's decision in Lake versus Rubin did not upset that precedent. In fact, Mr. Powell's reliance on that case is misplaced for the very same reasons that this court explained in Maxwell. Same argument was raised in Maxwell in reliance on Lake, that Lake provided a cause of action under Section 6103. This court...
Aren't we a minority of one among the circuits to see this dichotomy between the Privacy Act and FOIA? Didn't the Seventh Circuit, at least the Seventh Circuit, come to a different conclusion?
I'm not sure what the question is. I'm sorry, could you repeat?
Well, 6103 displaces the Privacy Act, we've held, and I think we've held that it does not displace FOIA.
That's my understanding.
We're stuck with that. And what I'm asking you is, isn't that a minority view of one among the circuits? Particularly the Seventh Circuit.
Whether the Lake decision is a minority decision in holding that Section 6103 supersedes the Privacy Act?
No, that 6103 either supersedes both or neither. That is what the Seventh Circuit held. I don't have the case in front of me.
I think that is correct. The Seventh Circuit has held that Section 6103 superseded both FOIA and the Privacy Act. In holding that Section 6103 supersedes the FOIA Act, however, the Seventh Circuit is certainly in the minority. The majority, it's only the Sixth and Seventh Circuits that have come to that conclusion. This court and other cases that we've cited in our brief have come to the opposite conclusion.
Well, then what is your best argument for why we should have this dichotomy between the Privacy Act and the FOIA? As far as 6103 displacing one but not the other.
Well, FOIA, as this court held in Church of Scientology, provides a full and complete adequate remedy for requests for disclosure of tax records. And so there's the adequate remedy there, which would certainly preclude any review under.
So is Lake wrong? Not that we could do anything about it, but why is Lake right?
I don't necessarily think that Lake is incorrect. As to the Privacy Act, the court held that 6103 governs because the Privacy Act did not give any judicial remedy in certain circumstances. And so in Lake, this court said that 6103 would apply. But Lake did not address the interplay between Section 6103 and the FOIA, which is the issue in this case. And under Church of Scientology and Maxwell, the FOIA procedures apply to any request for the disclosure of tax records. And that is the way that Maxwell harmonized Lake and Church of Scientology.
It seems that the law is muddled even in other circuits, because I had the same concern or question that Judge Henderson did. Lake, I think, cites a Seventh Circuit case called Cheek versus IRS, which is a one-page opinion. The Cheek, in turn, relies on a case called King versus IRS. And King says at the very end, after going through a whole bunch of language that seems to say that 6103 displaces FOIA, their final paragraph is that they say, we conclude that the provisions of section 6103 apply either independently or through FOIA exemption B3. So that's about as clear as mud. So I don't know that any of the circuits have kind of covered themselves in glory here in how they've like described this, but I guess the way that I've looked at it is that when Lake says that the Freedom of Information Act does not govern the disclosure of information, just as the Privacy Act does not govern the disclosure of information. When they were talking about FOIA, they were saying, well, the other Freedom of Information Act exemptions, because there are exemptions about protecting privacy, et cetera, right? But rather than use those, there is a statutory exemption here under B3, under 6103, that's going to govern the disclosure. And that's all that Lake was saying. And that's consistent with Maxwell. And that's consistent with Church of Scientology. And it's consistent with another case we decided called Gardner. What's your view of that?
I think that's right. I think that that's the way that Maxwell harmonized Lake and Church of Scientology. The Lake decision was a Privacy Act case, did not address the interplay between section 6103 and FOIA, which Maxwell pointed out is instead controlled by this court's decision in Church of Scientology.
Even if all of that is correct, then that means that the district court, you concede in your brief that the district court had subject matter jurisdiction. So then it was error then for the district court to dismiss the case on 12B1 grounds.
That's right. The dismissal.
So why then shouldn't we send the case back for the district court to sort it out, given that Mr. Powell says in his pleadings that he made FOIA requests for some of this information? Maybe he's collaterally estopped, maybe he's not, maybe he exhausted, maybe he didn't. We don't know from this record, and the district court didn't reach any of that. So why should we affirm?
Well, any FOIA claims that Powell may have made have certainly at this point been waived by not arguing in the opening brief or in the reply brief on appeal that the complaint stated a claim under FOIA. That has not been the argument. It's not been made. So if, to the extent that...
Well, why in this opening brief would he argue anything about whether he stated a claim when he's challenging the wrongful dismissal for lack of subject matter jurisdiction?
Well, Mr. Powell joined in the amicus brief, the opening brief under review now, and that brief asserts the argument that the APA provides a cause of action to enforce section 6103. There's no assertion or argument that that the complaint stated a claim under FOIA. So the government hasn't addressed that argument in the briefing. And frankly, it's either been abandoned or waived because it's not been included in the briefing before this court. It'd be too late at this point to assert a FOIA claim, I would submit. And so for that reason, this court, as it has done in other cases that were dismissed wrongfully on the basis of lack of subject matter jurisdiction can instead affirm for failure of the complaint to state a claim under Rule 12.6. And
I thought in his pro se brief, his opening brief, he says words to the effect of like, I made a FOIA request, which was proper. He didn't lay it all out, but he at least says that or says words to that effect. Am I wrong about that?
to that extent, I believe Mr. Powell was referring to requests made to the IRS administratively. He was applying the FOIA procedures that governed in making a request to the IRS, but in the litigation, he's never asserted a FOIA claim. In fact, the government counsel early on in the case, recognizing this, sent an email to Mr. Powell asking him whether he wished to amend the complaint because the complaint did not mention FOIA or the Privacy Act, and Mr. Powell declined to do that.
Well, I guess what I'm trying to figure out is, let's suppose I'm a district court judge and someone who's pro se pleads a set of facts that appear to be a breach of, appears to be a plausible breach of contract claim. And the defendants say, you know, your Section 1983 claims and your other claims aren't plausible. You should plead a breach of contract claim. And pro se plaintiff says, well, I'm leaving my pleading as it is. Is the district court judge at that point, when they get the 12B6 motion, supposed to just not construe the plausible breach of contract claim and just say, well, you've waived it? I mean, isn't that like counter to the way that we deal with pro se plaintiffs?
No, but here there's an explicit denial of reliance on the FOIA, which the district court found. And the reason seemed to be that Mr. Powell has brought many prior FOIA cases, and therefore perhaps the strategy was to avoid collateral estoppel defenses, whatever his reasons. But even assuming that the complaint had alleged a FOIA claim, certainly by now on appeal, Mr. Powell has either abandoned or waived that argument by not raising it in the opening brief on appeal or in the reply brief or yet here argument. There are, if I may speak briefly, Mr. Powell is seeking to draw a distinction between individuals seeking records about themselves as opposed to public seeking tax records, and is arguing that the Privacy Act applies to former while FOIA only applies to the latter. That very argument was also made in the Maxwell case, and this court held that the appellant's claim without citing any support that FOIA requirements cannot be applicable to their requests for personal information, but only to requests for public information. All of these arguments fail for the reasons already articulated by the district court. FOIA clearly does provide a remedy to a taxpayer seeking disclosure of his own tax records, and would apply and provided an adequate remedy for Mr. Powell in this case. There are no further questions.
Okay. We have your argument. Thank you. Mr. Shelley, why don't you take 2 minutes?
Thank you, Your Honor. Just like to make 3 points. One is that yes, the Seventh Circuit has adopted an approach that Privacy Act is displaced and the FOIA is displaced. The circuit would be alone saying Privacy Act is displaced, but FOIA is not. And I know, Judge Wilkins, you mentioned the Cheek case is just 1 page long, but it is a published decision. It's also 1 page long because the court was summarizing what it thought it did in King in holding that FOIA was displaced, and they said it would be extremely anomalous to have one displaced but not the other, and particularly because the legislative history.
I'm sorry, can you just clarify the state of play with the other circuits? Because my understanding was that the 3rd, 5th, 10th, 11th, and our circuits say that 6103 does not supersede FOIA.
Procedures. But
Well, you already said that there's no precedent for this bifurcated approach that you're proposing. So no other circuit has adopted that.
Well, correct, but what I
So
was.
when they say it doesn't supersede FOIA, they're not saying we should bifurcate.
Well, but those circuits are holding that FOIA is displaced, but the separate question is whether if the Privacy Act is displaced, would we be the only circuit also to say that FOIA is not displaced in that sense? But he didn't raise a FOIA claim. His claims are closer to Privacy Act claims to begin with, as I pushed before.
But previously, he's already filed numerous FOIA claims, and it seemed, and correct me if I'm wrong, it seemed like he was purposefully avoiding FOIA because he didn't get what he wanted under FOIA. So we thought maybe if I try the Privacy 6103, maybe I'll get something different.
Like, I think Mr. Powell's been at this for 10 years trying to get tax records, and he feels like he's gotten the runaround from the government, that they can't find them, and that actual tax returns for various corporations aren't able to be found is distressing and frustrating to him. He did try a different tack in this case, but it's not my understanding that if we had, for instance, a reversal here because it shouldn't have been dismissed for lack of jurisdiction, to send it back to the district court to sort out whether he does want to bring a FOIA claim and try once more with the government to try to get what he wants. It is not my understanding that he would object to that.
But the issue is what happened in the district court is not sort of like the hypothetical that Judge Wilkins raised, where a pro se claimant isn't sure what the cause of action is and perhaps chose the wrong one. This is a litigant who has used FOIA, understands FOIA, has filed FOIA requests, and purposefully avoided filing a FOIA request in this instance because it seems that perhaps he thought he could get something different if he filed a 6103 claim. That's what it seems like, because on this record, the agency counsel actually said to him, "Don't you mean to file a FOIA claim?" And he said, "No, I don't want to." So it seems like a little different from the typical pro se plaintiff. It seems that this was strategic.
I can't really speak to his motivation, but I can say he did file a FOIA request with the agency. He thinks he did. He thought he was following. To the district court. I think if he had counsel, this could be sorted out, and his 10-year dismay could perhaps come to an end.
All right, Mr. Shelley, you were appointed by the court to represent the client, and we thank you for your very able assistance.
Please, thank you.
Case number 23-1044, John Doe petitioner versus Securities and Exchange Commission. Mr. Cummings for the petitioner, Mr. Shirey for the respondent.
All right, Mr. Cummings, good morning.
Good morning, Your Honor. May it please the court, Tom Cummins on behalf of the claimant. This is an appeal of the Security and Exchange Commission's denial of claimant's whistleblower award application. The case comes down to a simple set of facts and turns on a single question. First, the fact.
Counsel, can you get closer to the microphone? I have a hard time hearing, and I'm trying to do everything.
Yes, Your Honor. Is this better?
Well, if you'll just get closer to the.
Okay. Is that?
Thank you.
Of course. So, as I was saying, this case comes down to a simple set of facts and a single question. The facts. Two co-venturers are working on a business project. One is the claimant's client. The other is stealing from the project. Claimant reports the thief. Pausing here, it's undisputed that claimant's tip led directly to the commission's investigation, which stopped a massive fraud and recovered tens of millions of dollars for the federal government. In short, it's undisputed that claimant did the right thing substantively. So the only question is, did claimant reasonably believe that reporting this thief could serve his client's interest? He did, and the commission abused its discretion in concluding otherwise.
So
Yes, Your Honor.
it seems that this case turns on sort of factual determinations by the commission. And it seems that there is evidence in the record that your client believed that his client could be a perpetrator and not a victim of this fraud, which would preclude the idea that him blowing the whistle on his client was in his client's interest.
Respectfully, Your Honor, there's no contemporaneous evidence that he believed that his client was involved. In fact, all of the contemporaneous evidence directly contradicts that.
So can I point you to a few parts of the record and ask you to address them? So didn't he say, while I did not yet have smoking gun proof of the misconduct by my client at the time I made the whistleblower submission, I had suspicions that the interests of investors were not being adequately protected. He also said, I considered that the tip would lead to an SEC investigation of the entire money trail. I would uncover any wrongdoing by my client. And the purpose of my tip was to alert the SEC to investigate the entire offering, including all affiliated persons and entities, including not only the third party, but also my client. So if he believed that his client was a perpetrator, it could not have been in his client's best interests to blow the whistle.
So a couple things there, Your Honor. First, he made that statement in 2022, which was 8 years after he had made this initial tip.
But it's supported by that substantial evidence in the record that supports the commission's finding.
So it's contradicted by the actual four corners of his tip. It's which state that he's seeking to have the project successfully completed. If he wanted the project to be successfully completed, and he knew that one co-venture was stealing from the project, and he suspected that another, it would make no sense to report it so that the project was completed.
That's arguable, but if it's supported by evidence in the record, we affirm, correct?
Yes, Your Honor, but it's also contradicted by the declaration of the commission's own attorney, who said that they thoroughly investigated the claimant and concluded that he neither knew nor should have known of the wrongdoing by his client because he didn't have access to that information. And even if so that's the first part. And then the second part is if he actually believed that his client was involved, then it would have been permissible under Rule 4.1-6B. But we're not asserting that he reasonably believed that his client was involved when he made the tip in 2014. Rather, he reasonably believed, as his own whistleblower submission states, that he was serving his client's interest, that he wanted the project to be successful. Now, in 2015, he did learn that his client was involved and he resigned. And then he sat for multiple interviews with the commission as well as other law enforcement agencies, and his cooperation enabled the commission's successful prosecution.
I understand that, but I think the question in this appeal is whether it was in his client's interest to blow the whistle.
Right.
And the commission found it was not, and there's substantial evidence supporting it. So even if you have arguments to the contrary, we're not sitting de novo and weighing these arguments. We're just making sure that the commission, that their findings were supported, and it seems to be.
Yes, Your Honor. Again, the only evidence is 8 years afterwards and is contradicted by the contemporaneous evidence. But that evidence is in the record, and to the extent that it indicates that he reasonably believed that his client was committing a crime, it would be permitted under Rule 4.1-6, subsection B, which permits a lawyer to make a disclosure of confidential information to prevent a client from committing a crime.
But that's not, you didn't make that argument in your brief.
That's right, Your Honor, because we believe that the record, read as a whole, unequivocally demonstrates that when he made the submission in 2014, he thought he was acting in his client's interest.
But his client didn't have an interest in the ultimate project as far as a financial interest. It wasn't a shareholder, right?
That's right, but
And his client wasn't like a partner in the partnership that owned the project, right?
his client was the corporation.
But that corporation was not a partner in the partnership that was constructing the items at issue, right?
That's correct.
So how is it in his client's interests to disclose this just because his client could get more work in the future or something? But I don't understand the argument.
So both benefits and detriments. The benefits would be it would receive revenue and profits from the successful completion of the project. And then the detriments, by fulfilling its contractual obligations, it would avoid liabilities to contract counterparties and investors. And then, of course, the knock-on effects, the successful completion of this project would allow its business to win future business.
And you don't dispute that what he disclosed were client confidences within the meaning of work product attorney-client privilege.
I would dispute that it's neither attorney-client privilege nor work product. It was very careful not to disclose any attorney-client material. And in fact, the only material that he disclosed was information that he obtained within the course of his representation about the person that he believed was stealing.
I spoke too loosely there. You don't dispute that it's confidential information that he disclosed that was learned and gained in the course of his representation of his client.
We agree that within the broadest reading of confidential information, it was technically confidential information, although it's important to point out that it was not his client's confidential information, further reinforcing that his disclosure both fulfilled the spirit and the letter of the relevant attorney conduct rule.
What difference does it make for the purpose of the rule whether it's his client's confidential information or not? I didn't think that the rule made any such distinction.
Your Honor, I think that these are rules of reason be applied with thought to the broader context. So you can't disclose attorney-client information without your client's express consent. You can disclose confidential information even without your client's express consent to the extent that you reasonably believe that it would serve your client's interest. And here this is potentially one step further. This is not confidential information of the client, but merely confidential information that you learned in the course of your representation of the client. So for that reason, that it was confidential information learned in the course of representing his client, one of the commission's alternative arguments falls flat. The commission argues that the disclosure was not authorized because it was not within the scope of his representation. The scope of his representation was the providing legal advice on the project in question, working with the investors on the project in question, but all of those were directed towards a single aim, the ultimate success of the project. And as his TCR, his whistleblower submission, expressly states, he's making the submission so that the project can be successfully completed. And if you're...
There are no questions, but I would like you, do you have your blue brief?
Yes, Your Honor.
All right. Could you turn to page 18? And while Mr. Shirey is arguing, on that page, the quoted language, that paragraph on the fourth line, you have added something that describes the regional centers, that is, entities such as claimant's client. And what I'd like you to do before you reply is tell me how this Regional Economic Development Authority fits within the definition of regional centers under the statute, or maybe you can do it standing there. But I think that's a unfair characterization of it.
Your Honor, I'd be happy to supply supplemental briefing on that point in a week of this argument.
I can't, but
I would be happy to provide you a supplemental brief on that argument. I wouldn't want to speak off the cuff and misrepresent anything.
all right, but you know the entity that your client worked for.
Yes, Your Honor.
I'd like to know how it fits within the definition of regional centers. You have added to that by saying entities such as the claimant's client.
My understanding is that my client was a regional center under the relevant federal program that authorized investors to qualify for immigration status if they made sufficient investments.
And you can't look at your file and find that site.
Not as I stand here.
All right, okay, thank you. Mr. Shirey. Is that as far as it goes? We've been having a heck of a.
May go a little.
Great.
Here we go. I think we're at the end. Good morning, Your Honors. William Shirey for the Securities and Exchange Commission. The commission, when it's designed its whistleblower program, was very careful to not greenlight attorneys taking their clients' information and using that information for their own benefit, the benefit of the attorney. So the commission created a regime that's based on preserving and promoting the duty of confidentiality. And as part of that regime, the commission's rules place the onus on attorneys who want to use their clients' information to explain how the disclosure fits within the limited exceptions that exist throughout this country to breach or to use information that would otherwise essentially violate the duty of confidentiality.
Can I
Yeah.
ask you something? We couldn't find another case in which an attorney, based on what his client did or didn't do, was awarded a whistleblower award. Do you know of any?
I am not aware of one, Your Honor.
Okay.
It is for the understandable reason, because an attorney taking their client's information and using it is so discouraged and subject to, as we discussed in footnote 21 of our orders, so subject to very limited exceptions. Returning to the point I was just sort of
But
addressing.
isn't it the case that even if it's not under the whistleblower awards, attorneys make disclosures to the SEC, Justice Department, on behalf of corporate clients all the time if there's a Foreign Corrupt Practices Act violation, et cetera, that, at some point, the attorneys decide that it's in their client's interest to disclose that, even though it will subject their company to scrutiny, investigation, maybe even prosecution, because it's and the government encourages those disclosures, and the company then throws the guilty employees under the bus and tries to have some sort of remedial measures, et cetera, and better prophylactic measures. So it's not unprecedented for lawyers to disclose kind of inculpatory confidential information to the government, right?
That's absolutely correct, Your Honor. But in those contexts, the attorneys are coming forward as in their sort of fiduciary capacity and the representative capacity, speaking for their client.
And they're not making money from it.
No, we have not had a situation like that to date. No. And they're also in the run of cases doing it with the express authorization with their client, where they've engaged with their client. They've informed the client about the potential risks, the upside and the downsides of coming forward and admitting that there's been a violation of the securities laws and working to remediate that.
Yeah, my point isn't that the cases are similar. My point is that sometimes disclosure of client confidences to enforcement authorities does serve the client's interests, right? Which is the whole point of this Florida Bar Rule 4-1.6C1, right?
In that case, typically in the cases that you're describing, Your Honor, it would be actually with express authorization to come. Here, there had been no dialogue with the client that has ever been alleged, and the attorney took it upon himself, sort of essentially going rogue, to decide it's in my client's interest. And on that point, unlike what you're describing, Your Honor, which is a situation where the attorney comes forward to ultimately protect the interest of the client, the overall interest of the client. If you actually go back and you look at pages 76, I believe they're pages 76 and 77 of the joint appendix. That's the declaration that was submitted, the sworn declaration that was submitted by Doe. Doe nowhere alleged, nor in any papers that he submitted to the commission, that he was doing it to protect an innocent client or to in any way that there had been any discussion with the client about the consequences, the downside risk of coming forward that you would normally expect in that sort of fiduciary relationship of providing a client advice and working through what is the best next step.
But what I'm trying to, I guess, clarify here, and I think, we have to distinguish, is, a human being hired the claimant to be a lawyer. That human being was a manager of an LLC, but the LLC was the client, right? The company, the entity was the client. The person who was paying the bills and who had hired him was kind of the client because they hired him, but ultimately the company wasn't the client, not that individual. And if that one individual is corrupt, what conversation can the lawyer have with that corrupt individual about what the company's best interests are?
And Your Honor,
how is that conversation supposed to go?
And Your Honor, that is a consequence of the duty of confidentiality. Attorneys, if there is no one to talk to, the attorney's principal responsibility is not to sort of end that fiduciary capacity, decide, notwithstanding the fact that the only representative official at the company, the only person who can speak for the company in any kind of authoritative capacity can't actually authorize it. It's not consistent with the attorney-client relationship for the attorney then to decide, nonetheless, he or she is going to come forward to the commission.
Suppose the entity is a charity and it's raised, millions of dollars to, hurricane, victims, and it's controlled by one person who hires a lawyer to represent it. And that lawyer learns that person who controls the charity is stealing all of the money. But the charity is the client of the lawyer. So it wouldn't be in the client's interests for that lawyer to disclose that all the money is being stolen without kind of like consulting with this corrupt individual first. That would be a violation. That would be inconsistent with the interests of the client.
So, Your Honor, a couple things. I think that the clearest answer to that actually is that the interest of the client, and this is discussed in the comment to the Florida rules, is the interest of the client turns on the question of whether the disclosure is necessary. And now I'm quoting from the comment, Florida rules, in carrying out the representation, carrying out the work that the attorney is hired to do. So there may be instances that you're talking about, Your Honor, where a general counsel may make a determination under the particular facts and circumstances, under the particular applicable rule, that it is in the client's interest. But what we have here, Your Honor, is an attorney who was principally, according to his own declaration submitted in September of 2021, he was principally an immigration attorney. He was then he was then asked to assist with certain preparation of offering materials. That is a far cry from someone who you're talking about, Your Honor, who might be a compliance official, who might be a general counsel, who has to make decisions based on the applicable rules under the particular facts and circumstances, whether it makes sense to do it. That is not the case we have. And for obvious reasons, the commission's not in the best situation to opine about the application of the various rules in those more complicated situations that might come closer to the heartland of what an interest of the client is. That's not what we have here. Attorneys are fiduciary. They do the work that they're hired to do. The best interest of the exception, the best interest of the client exception is an implied authorization, as the rule says, to make necessary disclosures, disclosures that the attorney believes are reasonably necessary. Reasonably necessary is an objective standard under the Florida rules. Whether an attorney, a prudent attorney, is what the Florida rules say, the terminology, the definition of reasonably, whether a reasonable attorney would believe that coming forward to report misappropriation that their own client may be engaged in, and to have that client investigated and potentially subjected to an enforcement action, is not what particular Florida rule contemplates.
But I guess that's why this is like a little, it seems a little bit like the SEC is kind of trying to have it both ways a little bit. Because the client of the claimant was not the person who was doing the misappropriation, right? Claimant did not represent the individual. Right?
Correct.
So
That's correct.
So when the claimant blows the whistle, the claimant isn't blowing the whistle on his client, right? Because his client is the entity. His client is not the individual person who is doing the misappropriation, right?
That is not, Your Honor, according to the declaration that's at page 76 and 77 of the joint appendix. And I'm happy to read to you from it, being sensitive to the fact that we're pardon me, pages 84 through 85. Doe actually says that the purpose in the disclosure in my whistleblower submission was to...
What paragraph are you on?
I'm on paragraph 1, but paragraph 2, and there's a number of paragraphs that carry through with the same concept, which is the purpose of the disclosure in my whistleblower submission was to prevent a crime being committed. Exerting out, then my client. That is not someone who's stepping forward to protect their client from someone who's being who's having a co-venture who is stealing from the asset or stealing from the investor funds. If I may have just 20 seconds. Ultimately, the way that the commission's rules work, an attorney has to demonstrate that they fall within one of the narrow exceptions. The burden is on them. Here, the commission determined that, notwithstanding the potential circumstances that might exist in some cases, that here the client or the Doe did not explain, not grapple with how subjecting his client to an investigation, which he says was his goal, to subjecting his client to a potential enforcement action, which he said was also something that was in his, that promoted him coming forward or led him to come forward, how those fit within the totality of the overall circumstances, such that it was in his client's interest. And in failing to do that, failing to carry that burden, failing to make that factual showing, the commission made a determination that this court should, factual determination that we believe this commission, this court should have.
Right, I've got a couple questions. That took me a while to get pages 76 and 77. What are you specifically pointing to there?
I'm sorry, Your Honor. I was specifically I had the wrong pages. Pages 84 through 85 is what I was specifically referring to. That was the declaration from January 2002. But actually, Your Honor, page 76 is a great example as well. And since you're there, page 76 on the carryover sentences at the end, just backing up for a second, there had been a preliminary determination here where the commission determined that the crime fraud kind of exception didn't apply. The response that's on page 76 to 77 is actually Doe stating that the commission had misunderstood his TCR. He states, I was actually, and I'm going to try to read it carefully here. He says, the commission implies that my purpose in the disclosure was only to prevent the co-venture, who was not my client, from performing this misappropriation. In fact, my goal was not solely to prevent the co-venture from committing a crime, but also to prevent my client from committing a crime. That is that is Doe correcting a perceived misinterpretation of the facts from the TCR, from the original tip that he made, where he believed that the commission had only understood the tip to involve reporting the wrongdoing of the co-venture. He's actually saying here, I'm outing my client based on suspicions and concerns that I have about my client's misconduct.
Okay, and then can you turn to your order, which is at 89 to page 96. And we may have touched on this already, but it may be waived. But my question goes to the sentence at the bottom of 8. Page 8, are you of the order?
I'm at the order, yes, Your Honor. What page?
Okay, that sentence, while the Florida rule permits limited disclosure of client confidential information when a lawyer reasonably believes disclosure is necessary to prevent the client from committing a future. Okay, we know that. But then the rest of for ongoing crime. Now, why wasn't this why did you conclude that this wasn't an ongoing crime? Wouldn't it be reasonable? And again, it may be waived. I'm just trying to figure out how you analyze these for another case. If someone reports a crime that's already been committed, what do you use to determine that it isn't ongoing or it is ongoing? Wouldn't it be reasonable to for a whistleblower to say, my client committed this crime without saying, and he is continuing to commit this crime?
So, Your Honor, this is where I think it comes back to the Florida rules and the narrowness of the overarching duty of confidentiality that sort of permeates the entire attorney-client relationship. It's the foundation of it, an important part of the foundation of that relationship. And so the Florida rules put the onus on the attorney to make sure that they fit within this very narrow exception. What Your Honor is talking about actually sort of would go exactly against what Florida has directed, that an attorney has to have a reasonable belief that there is something ongoing. And so that's the critical answer, I think, and it's talked about on page 21. I don't think that opposing counsel, footnote 21 of that order talks about how narrow the exceptions are.
And Florida is very harsh. I mean, that first Porterbauer versus Knowles, the client's statement that she would lie in court did not establish a sufficient basis.
And if Your Honor, if I can just for a second, that there's and when the commission promulgated the rules, they were very conscious that The aggressive enforcement of the duty of confidentiality is actually consistent with the goals of the whistleblower program. The ultimate goals of the whistleblower program are to promote the effective enforcement of the securities laws, compliance with the securities laws. The cornerstone of the underlying logic of the duty of confidentiality, so that clients talk to their counsel. They give the information that they may be engaged in inappropriate conduct. They ask, what should we do? This has been discovered. This has been going on. And they get counsel from their attorneys.
I get that, but the ABA Model Rule 1.6 does not include this exception C1 that's in the Florida rule. The ABA Model Rule, when it goes through all of the instances where a lawyer may reveal confidential information, didn't include what's in C1. And from my reading on that, the ABA, whatever committee recommended language akin to C1, but a lot of lawyers objected to that and said, you know, that's a pretty broad exception to allow a disclosure that a lawyer reasonably believes is consistent with the interests of their client. And so the ABA took it out of the model rule. But Florida, for whatever reason, put it in their state rule. So a lot of the opinions in court, you know, both ethical opinions and bar opinions and court opinions that talk about Rule 1.6 confidentiality are based on state rules that are modeled on the ABA model rule completely and don't have this provision C1 in it. So in that sense, Florida is broader than most jurisdictions because it has this exception. Did the commission grapple with that?
So that argument was not raised at any point during the briefing, but I think the core point is, Your Honor, that even under existing Florida precedent, even under the commentary to the Florida rule, it has to be, I can try to find, or we can submit a supplemental if the court wants. Actually, I think it's cited in our brief. It has to be a representation necessary in carrying out, it has to be a disclosure necessary in carrying out the representation. So whatever the disconnect may be between the ABA model rule and the Florida rules, it's undisputed here that there was nothing about, I would argue it's undisputed, about counsel's role as a senior immigration, I don't want to disclose the full title, but it was an immigration attorney at the client who participated in assisting periodically with offering materials. There's nothing about that that empowered this individual to be an oversight compliance official who might somehow have it such that it was necessary in the course of his representation, necessary, that's the word in the rule, Florida, to disclose this information to the commission. May I answer one, and I know I've gone on too long, Judge Pan, one thing my opposing counsel said, he mentioned that the staff attorney at the SEC's declaration stated that that declaration, there had been no evidence found that attorney knew of the client's wrongdoing. That's not entirely accurate. What the declaration says, and this is on page 62 of the joint appendix, paragraph 13, is that the commission found that the claimant did not know, and I'm paraphrasing, that the misstatements and representations that were put into his assistance into the offering documents were wrong, were misrepresentations. And what the attorney here subsequently learned is, as time goes on, is that there had in fact been misappropriations by various parties here. So I just wanted to clarify that it's a narrower than the representation, and it will speak for itself. Thank you, Judge.
All right, thank you. All right, Mr. Cummins, why don't you take 2 minutes?
Thank you, Your Honor. Microphone, right. Returning to that last point, that what my client subsequently learned, what the claimant subsequently learned was that his client's principal was involved. So Judge Wilkins, you're correct that there's no evidence in the record that he reported it to his client because his client wasn't the individual, it was the company. But if I could direct you to page 92 of the joint appendix, this is from the final order. Claimant brought his concerns to the employer's manager before reporting to the SEC, but did not feel that his actions effectively addressed the situation. Dropping down to the footnote, according to the claimant, the employer did not have a compliance department or compliance officer for claimant to report his concerns to, and claimant did not believe that further reporting to the employer's manager would be useful in preventing harm to investors. Claimant resigned from the employer due to increasing concerns about the employer's manager about a year after submitting the tip. Again, when he made the tip, he did not know that his client was involved, and his client was not the individual, but the company. He learned about the company's involvement, he resigned, and he continued to participate in the investigation. When he made the tip in 2014, he would have qualified indisputably for the award.
Why did he say that he was reporting a crime by his client repeatedly later on then?
Your Honor, I don't know, but I believe that hindsight and the 8 years of participating in this investigation, they have changed his view of the world. But from the four corners of the TCR, when he made it, he said he wanted the project to be successful.
Is there precedent that says that the SEC is only allowed to consider the four corners of the TCR and can't consider statements that are made afterwards?
No, Your Honor. Unless there are any other questions, we respectfully ask that reverse the commission's decision and remand it for an award.
Okay, thank you.